Good morning, this is Erick Becker. I'm the presenter for today's webinar. We'll be starting in about a minute. Good morning, everybody. This is Erick Becker. I am the presenter for today's webinar on employment law update for 2018, the expanding reach of workplace regulations. I am the head of the Labor and Employment Law Department here at Cummins and White. We're so glad that you could all join us this morning. We've got a lot of good information to cover with you about some of the changes that have gone into effect here in California and federally, and some things to anticipate in the upcoming year. A couple of preliminary things. Number one, if you want a copy of these slides, please email me after the presentation. My email address will be on the last slide, and I'll be happy to send you a PDF of today's slides. Second thing, if you do have questions as we go along, please type them into the question dialog box. And what I will be doing is stopping at the end of every segment of the training seminar and talk about and answer those questions. And of course, at the very end, I'll be glad to answer any questions that you type in. Or if you want to send me questions afterwards by email, please feel free. So we've got a number of things to talk about when we're covering expanding reach of regulations. And the reason why we titled it the expanding reach of regulations is that California has decided to spread the love to a lot of smaller employers that now are subject to regulations that they weren't subject to before. And a lot of employers are used to certain numbers of employees being a trigger for coverage under certain laws. The most common trigger is having 50 employees. If you have 50 employees, you're subject to a number of laws, including FMLA, CFRA, sexual harassment training, etc. But California has decided, no, we want to spread this down to smaller employees, and we'll talk about that as we go through the new laws for today. So it's a bit of a good news, bad news situation. The good news is on a federal level, we have seen a relaxation of regulations in the employment sphere, which I'll talk about at the end. And I anticipate that will continue into 2018. But of course in California, because everything now seems to be a reaction to what the federal government is doing, if the federal government wants one thing, California says we're going to go in the opposite direction. And it's no different in employment. We've seen an expansion in a number of different areas of the regulations that govern employers, in addition to the continuing increase in employment litigation. So there's a number of things that you need to be aware of and need to plan for as you look at your policies and procedures and practices in 2018 that we're going to be covering today. But first, I do need to give you the good old-fashioned legal disclaimer. So this webinar should not be considered as providing any legal advice or legal opinions of any kind. It is intended to provide a concise, practical guide and information on new laws and their potential impact on employers. You should always seek the advice of your legal counsel to review specific matters as well as relevant case law. And the reason why I always have to put that disclaimer in is that in employment, especially, every situation is different. The advice on how these laws apply and what the employer should do is always going to depend on the individual facts of the situation, the size of the employer, the nature of the job that the employee is working, and the specific facts regarding that employment situation. So with that having been said, let's start talking about what we have as new laws here in California for 2018. So our first new law, and this is a very important new law, has to do with parental leave. This is also colloquially known as baby bonding leave. And those of you who have 50 or more employees are familiar with this concept of baby bonding leave, because under the California Family Rights Act, if you have 50 or more employees, you have to grant to new parents a leave of absence of up to 12 weeks to bond with their newborn child. Now, California said, you know what, this baby bonding leave is so important. We don't want to just limit it to larger employers that have 50 or more employees. No, we want to expand this to cover employers with 20 or more employees that are working within 75 miles. So this new parental law is going to apply to any workplace where the employer has 20 or more employees that work within 75 miles of each other. For instance, if you have 10 employees working in Anaheim and you have 15 employees working in Riverside, that's within 75 miles, and all of those employees are now going to be subject to this new parental leave requirement. Now, one of the things that you need to understand if you are now going to be covered under this new law is that it is not as broad as the California Family Rights Act in terms of the leave. The Parental Leave Act only grants leave to care for a newborn, adopted child, or foster care placement. It does not grant leaves like the CFRA for the serious medical condition of the employee or family member. So, if you now have employees that are covered under the parental leave law, they don't get to take time off because they're having a serious medical condition or because they need to care for a sick loved one. That is strictly limited to employers that are covered under the FMLA or the CFRA, and that still only applies to employers with more than 50 employees. So important to recognize this is only a leave granted for baby bonding. In order to be eligible for this leave, and this is the same standard that is used under the FMLA and the CFRA, you must have worked for the employer for at least 1 year, and during that 1 year period, you must have worked at least 1,250 hours. So, in other words, if you're a very limited time employee, you're temp or you're part-time and you don't work that many hours, you're not going to be eligible for parental leave. And if you're in your first year of employment, you're not going to be eligible for parental leave. The parental leave allotment is identical to CFRA and FMLA. It is 12 weeks of leave that must be taken within 1 year of birth or placement of the child. So if a father, for instance, wants to take time off 6 months after their child is born, they would have up to 12 weeks that they could be able to be absent from work, and that would be a protected leave. Now, one thing I want to mention here, this is unpaid leave. The employer does not have to pay, similar to FMLA and CFRA, the employer does not have to pay the employee while they're on leave. The employee can apply for paid family benefits that are granted by the state and are paid through the payroll tax withholding. Paid family leave's been around for a while. If an employee takes one of these parental leaves and wants to apply for paid family leave, they can do so. But whether or not they get paid family leave or not, if they're eligible for parental leave, you have to grant them up to 12 weeks. Another issue, can that be taken intermittently? And I think the answer is yes. That can be taken intermittently up to the 12 weeks of leave. One of the important things in this new law that is a little bit different from FMLA and CFRA, is that at the start of the leave, you must give the employee in writing a guarantee that when they return, they will be returned to the same or comparable position that they had at the start of the leave. So you have to give something to that employee in writing that says, I'm granting you a leave, you requested, let's say 10 weeks, here is your expected date of return at the end of the leave. When you return, you will be returning to either the same position that you have now, which is X, or a comparable position. And if you don't return as of the expected date of return, and you haven't requested additional leave, then we will take that as a voluntary termination. So it's really important to have that in writing and deliver it to the employee. And I would suggest that you deliver it by mail. And you just need that documentation to show that you gave that employee that guarantee. And when they come back, you got to return them to the same job or a comparable job. What's a comparable job? It's going to be the same rate of pay, the same shift, generally the same duties. You can't demote them, you can't transfer them, you can't cut their pay. They're essentially guaranteed the same job. Now, another thing to know about parental leave is that it does not run concurrently with pregnancy disability leave. For those of you that are not familiar with CFRA, CFRA, the 12 weeks that's granted to employees of employers that have more than 50 employees, does not run concurrently with pregnancy disability leave. And this new parental leave, they adopted the same rule. What does that mean from a practical standpoint? What it means is that if someone, a female employee, has a disability resulting from their pregnancy, whether that's because of the childbirth or some condition that occurs before the child is born or after the child is born, they have a right to up to 4 months of leave. In addition, once their pregnancy disability leave ends, so let's say they're out because of a disability for a 3-month period. They had a difficult pregnancy, they had a C-section, doctors put them out for 3 months. At the end of that 3 months, they can decide, you know what, I want to take an additional 3 months, an additional 12 weeks to care for my newborn. So that total leave could be 6 months, up to 7 months, because pregnancy disability leaves can be up to 4 months, and of course they would have 12 weeks under this new parental leave law. So you have to understand too that during that period of time that people are on parental leave, you have to maintain benefit coverage during the leave. In other words, they have to be eligible to continue being covered under your benefit plan, and they have to pay whatever premium amount that is required, just like if they were normally working. But you have to maintain their coverage and pay whatever portion of the premium that the employer typically pays while they're out on parental leave. Last thing I want to mention about parental leave is this can apply in situations where you are currently an FMLA CFRA employer at one of your work sites, but another work site that's not within 75 miles has between 20 and 49 employees. So let me describe a scenario. Let's say you've got a location in Los Angeles where you've got 51 employees. The employees at that location are eligible for CFRA FMLA leave. But you've got a location in Fresno, which is more than 75 miles from LA, that has 25 employees. Up until now, those 25 employees in Fresno were not eligible to take FMLA or CFRA leave. But now, they would be eligible for parental leave because there's more than 20 employees at that work site. They're not eligible for CFRA FMLA. It doesn't make them eligible for the full boat of leave entitlements, but they would be eligible for parental leave now because there's more than 20 employees at that work site. So very important if you have multiple locations to understand that. Do we have any questions regarding parental leave? Okay, fantastic. I'm going to move on to our next subject, which is salary history of applicants. So one of the things that we talked about last year was some changes to the Fair Pay Act. The Fair Pay Act is the law that requires employers to not discriminate in wage and salaries when it comes to gender, race, and national origin. And under the Fair Pay Act, employers were previously prohibited from relying on the prior salary of applicants in setting a wage or salary, because the purpose of that was to avoid situations where maybe a male employee had a salary history that would be higher than a female employee because of the past discrimination, and relying on that past salary would just further that discrimination into the future. So that was the point under the Fair Pay Act that was already in place. But the legislature said, you know what, that's not good enough. We need to expand this so that we further our goal of preventing pay disparities based on gender, race, or national origin. So they adopted an amendment to the law that says that employers are now expressly prohibited from asking applicants about their salary history or prior benefits. So if you have an application for employment and that application asks for what was your pay rate at your prior employer or what was your salary at your prior employer, you have to remove that from your application. You cannot ask applicants about salary history or prior benefits on the application itself or verbally in an interview. You can't ask them, so, hey, what did you make at your last job? Okay. Or what their benefits were. Now, I had a question come up just the other day. Does that apply to commissions and bonuses? And, you know, I think it's one of those things where it's better to be safe than sorry. I wouldn't ask people about, you know, what their commission rate was or how much commissions they earned at their past employer until we get some clarity around this law. You must also disclose to an applicant that requests it what the pay scale is for their particular job. Now, the interesting thing about this is that the pay scale is not defined. So the law doesn't say, what does that, you know, does that mean the pay rate of everybody in that job? Does that mean the starting pay for the job and what they could expect in terms of increases over time? It's not really defined. But the important thing is that you only have to disclose that if it's requested by the applicant. And I think to be safe, if you have a written pay scale for a particular position that the applicant is applying for, that if they ask for it, you should probably disclose it. If you don't have a written pay scale and it's just based on merit increases, then I would just tell the employee, here's the starting wage, and you'll be eligible for merit increases based on our policies. Okay, one other important thing to know about this new law is that the law specifically says that if an applicant voluntarily discloses what they were paid, that is not a violation, okay? As long as the employer didn't ask for that information, if the employee says, oh, hey, by the way, I made $45,000 at my last job, so I'm expecting at least $50,000 if you want me to take this position, there's nothing wrong with the employer getting that information, okay? But you cannot make the hiring decision based on the prior salary. Okay, in other words, you can't say, well, you know what, your prior salary was $45,000. We're not really comfortable with that, so we're not going to hire you based on that. So don't put anything in writing, no emails, nothing like that, saying, hey, I think this woman made too much in her prior job, let's not hire her, okay? Now, you may consider you may consider their prior salary that was disclosed in setting their new salary, okay? But you cannot justify a pay differential based on that prior salary. Okay? In other words, you can't say, well, you know what, this guy made $45,000 in his last job, so we're going to pay him $50,000 in order to attract him to come here, but all the female employees doing the same job, we're still going to only pay them $45,000. That would be a problem, okay? So again, it's very important to make sure that in your internal documentation, nobody talks about things like, hey, we need to pay this guy $47,000 because he was paid that previously. Can you ask an applicant for what salary they would like or what salary they expect? Yes. There's nothing in this new law that prohibits you from asking either on an application or in an interview, well, what salary would you like to receive if we offered you this job? Nothing wrong with that. You can still do that. Okay, any questions about that particular topic? Okay, fantastic. I just want to remind you that if you want to ask questions about any of these topics, we can also answer questions at the end of the webinar. So let's go on to our next topic, which is probably one of the most complicated areas that has changed in 2018, and that has to do with criminal background in the hiring process. Okay, so hold on one sec. Okay, so last year, the city of Los Angeles, and prior to that, the city of San Francisco, adopted something called ban the box. And all ban the box means is that you cannot put on an application a box for either yes or no, have you been convicted of a felony? And that's typically what most applications have had in the past, with all the disclaimers about marijuana convictions and convictions that are more than 7 years old, et cetera, et cetera, et cetera. Well, the California legislature decided, what LA and San Francisco did is a great idea, and so they adopted the ban the box concept on a statewide basis effective January 1st. So what does that mean? It means that you cannot ask applicants about criminal convictions, either on the application or in an interview. So you cannot have that box on your application anymore where people check either yes or no, have they been convicted of a felony. You need to change your application, remove that from your application, and you can't ask about it in the interview process. Now there is an exception, okay, and that is if a background check would be required for the position under state or federal law. So for example, certain positions require a criminal background check because of SEC rules, Security and Exchange Commission rules. Some positions require a criminal background check because you're dealing with children. If that is the case, and the federal or state law requires that you background check criminally all individuals offered hire, then you can still ask about it on the application or an interview. But if it's just for a regular job and there's no legal requirement to criminally background check somebody, then you cannot ask about it on the application or in an interview. Now, does that mean that you cannot criminally background check people? No. All it means is you can't ask about it until you make an offer of employment. Once you make an offer of employment, and you should be making that offer conditioned on the employee passing or being criminally background checked, then you can go ahead and check their criminal background. But this is where it gets complicated. Okay? So you can still do criminal background checks, but the legislature decided to set up a series of hoops that you have to jump through if you're going to make a hiring decision based on whatever shows up in the criminal background check. So let's talk about some of these new rules that are applicable statewide. Number one, you cannot consider any of the following when you're making a hiring decision, whether that's before or after making a conditional offer of employment. You cannot consider an arrest, which did not result in a conviction. So if their criminal background check shows that they were arrested last year, but there's no conviction, you cannot consider that in deciding whether or not to offer or to withdraw your offer of employment. You cannot consider whether the individual participated in a pre or post-trial diversion program. That happens a lot with some drug convictions where instead of a conviction, they're diverted to some sort of rehab program. You cannot consider that. And finally, you cannot consider convictions that are sealed or expunged. Sometimes, for whatever reason, those show up on background checks, and you cannot consider those convictions when determining whether or not to withdraw your offer. So let's talk about what happens if you do a criminal background check and a conviction pops up and you got to decide, you know what, we're just not comfortable with hiring this person. What do you have to do? If a conviction is revealed in the background check, you cannot deny employment, you cannot withdraw your offer unless there's a direct and adverse effect on the ability to perform the specific duties that the person is being hired for. And in order to determine whether there's a direct and adverse effect, you must conduct an individualized assessment of the situation. So you cannot have a blanket policy that, hey, we're not going to hire people who have convictions for drug offenses. We're not going to hire people who have convictions for DUIs, et cetera, et cetera. It's got to be an individualized assessment based on the following criteria, okay? So when you're doing this assessment, and by the way, you do not have to do this assessment in writing. The law specifically says there's no requirement to do a written assessment, but from a practical standpoint, if you're going to deny employment to somebody, it's probably a good idea to have something in writing to document your decision-making process in case it's ever challenged. So when you do this assessment, you must include the following, you must consider the following factors. Number one, the nature and the gravity of the offense. What were they convicted of? Is it a serious crime? Is it something that is really going to impact their ability to do their job, or could have an impact on the risk to the employer? For instance, if you're hiring somebody to do accounting work and they're going to have access to company accounts, and you see that they got a conviction for embezzlement, that'd be a pretty serious offense, and the nature of the offense is directly connected to the type of job that they're performing. So that would be pretty significant factors that could justify not hiring them or withdrawing the offer of employment. Second, you have to consider the time that has passed since the offense. Did this happen last year? Did it happen 20 years ago? Obviously, the longer it's been since the conviction, the less this factor would support withdrawing the offer. And finally, what's the nature of the job sought? Okay, using my previous example, if somebody's applying to be a short order cook, okay, and they got convicted of embezzlement, well, there's really not much of a connection between those two jobs in terms of, hey, an embezzler can still, you know, cook a burger. So you have to look at all of those different factors in deciding whether or not you're going to withdraw the offer. Once you've done that individualized assessment, if you decide to withdraw the offer, okay, you have to recognize, first of all, that is only a preliminary decision. You have to go through a process where first you notify the applicant in writing that you have made a preliminary decision to withdraw the offer, and you must allow the applicant to respond to that before you make a final decision. So let's talk about what the notification is that is required in those circumstances. Your written notification to the applicant must include a description of the conviction. You know, the background check revealed that there was a felony conviction. A copy of the background report itself. This is the report that we received. A copy of it is attached. You must notify the applicant that the decision to withdraw the offer is a preliminary decision only, and that you will consider any response that the employee has. And you must give notice that the employee has 5 business days, to respond to that notice. And you must explain that the employee can respond the following ways. The employee can dispute the conviction record. Hey, I know this conviction record says it's Erick Becker, but that wasn't me. It's a different Erick Becker. Okay? Now, if the employee disputes the conviction record, then they have an additional 5 days after they dispute the conviction record. They got to give you notice somehow that they're disputing that. They have an additional 5 days to provide evidence to show that the conviction record that they were supplied is incorrect. Alternatively, and this is an either or, okay? They can either do this or they can do this. They can also offer an explanation of any mitigating circumstances or any rehabilitation that's occurred since the conviction to say, hey, I'm a changed person. I know this was a long time ago. I went through a rehab process, et cetera, et cetera. So you need to set this all out in the notification to the employee and give that employee time to respond. If the employee responds and provides that information, you must consider the evidence offered before you make a final decision on whether or not you're going to withdraw the offer. And you must notify the applicant in writing of that final decision. And your notification must say that it's the final decision. It must include any description of an internal appeal process. Hey, if you disagree with this, you can contact the president of the company, and he will consider any further additional evidence you may supply. And your notification must describe the employee's rights to file a charge with the Department of Fair Employment and Housing if they believe that the decision to withdraw the offer was discriminatory. That's a lot of stuff. That's a lot of stuff. And I think my advice to employers in this situation is you need to really analyze whether or not it makes sense. And in some circumstances it does. But it makes sense to make employment decisions based on criminal background checks. Because if you are going to make that decision, hey, we're not going to hire this person because this popped up on the background check, there's quite a few hoops you have to jump through. And you do create a risk of a discrimination case. For instance, if you decide not to hire somebody because they were convicted of petty theft, but you hire other employees who are, let's say, Caucasian, who were convicted of more serious crimes, and the person that you chose not to hire was a race other than Caucasian, you could have a pretty significant lawsuit in that situation. So my advice to you is be cautious. If you're going to make decisions based on criminal background checks, get legal counsel, make sure that you've got some good advice in that situation. Okay, any questions? Well, there was a question in the dialog box, but it doesn't look like it was completed. Maybe it was answered. If you still have a question, feel free to type it in again, or you can type it in at the end. Okay, that was probably one of the most complicated new laws. Let's move on and talk about something that's not really a new law, but it is having an impact out there in the workplace, and that is marijuana legalization. I've talked about this over the past year, and now, of course, January 1st, 2018, it is legal to possess and use marijuana under Proposition 64. So, as you all probably are aware, because you've seen it on the news, effective January 1st, You can purchase marijuana retail without medical certification and go to the privacy of your home. And, you know, Taco Bell and Jack in the Box are running specials on late night munchies. But the important thing from the employment perspective, and this has been in the news recently, federal law still prohibits the possession and use of marijuana. And because federal law still prohibits the possession and use of marijuana, it is illegal for employees to use it. And it is legitimate under Proposition 64 to have a policy and enforce a policy saying that you will not permit employees to use, be under the influence of, or have marijuana in their system if they're in your workplace. So what does that mean? It means, and I've got a lot of questions on this recently, it means, yes, you can still test people pre- and post-employment for marijuana, and if they test positive, you can terminate their employment. The question that's come up is, what if people say, hey, I'm not under the influence of marijuana, I used it over the weekend 2 weeks ago, and it stays in my system, and it's legal under California law, so how can you terminate me? The answer is, doesn't matter. Doesn't matter when you used it, doesn't matter how long ago you used it. If you test positive for marijuana, you can be terminated from employment. And employees need to understand that because a lot of them think, now I can just use it on the weekend, it's no big deal. Now, are you going to go out and random test people? No. Unless you have certain safety-sensitive positions, you cannot randomly test. But in certain circumstances, provided that you have a compliant policy, okay, you can test people for reasonable suspicion. If someone comes into work with bloodshot eyes, and they're talking really slowly, and they're stumbling over their words, that would be reasonable suspicion to test somebody. And in that situation, if they test positive for marijuana, you have the legal right to terminate their employment. So one of the important things that you should do is look at your drug and alcohol policy to address this issue of legalization. And there's a couple of different things that you can do to make sure that your policy is clear on this topic. Here's some sample language that you can use to add to your policy. First, please note that the use, possession, or being under the influence of marijuana, whether prescribed or not, remains illegal as a matter of federal law and therefore is prohibited by company policy. Here's another alternate. Illegal drugs includes drugs, the possession or use of which is prohibited as a matter of federal, state, or local law, which includes marijuana. Use of marijuana is still illegal under federal law, whether obtained by prescription or not. So something in your policy needs to signal to employees that, hey, just because California is now a legal pot state doesn't mean that you get to use it. Okay, we have a question. We are a preschool. Can we send someone home if they come to work reeking of marijuana? Are we required to test them? Well, I think the answer to that is someone comes to work reeking of marijuana, I absolutely would test them, okay? You can certainly send them home, but your disciplinary action is based upon the fact that they are under the influence of marijuana. And if you didn't test them, how would you be able to prove, other than just saying, hey, they smelled the marijuana, that they were actually under the influence? So my recommendation in that circumstance is that obviously somebody coming to work smelling of marijuana, that would be reasonable suspicion. You should test them to determine whether or not they're under the influence. Who knows? Maybe they went to, the Grateful Dead aren't around anymore, but, they went to a concert the previous night and everyone around them was smoking marijuana. Well, that's probably not going to test positive, but that would be a legitimate excuse, and you couldn't terminate them just because they smell of marijuana. That's why you need to test them. Now, in that circumstance, if you believe they are under the influence, please do not send them to the testing facility on their own. Make sure that they have a ride to and from the testing facility so that you're not putting them out on the road and risking them getting in an accident or something else. Okay, good question. Thank you. Do we have any other questions before we move on? Excellent. So let's talk about harassment and discrimination. Obviously, something that has been in the news tremendously over the last couple of months. And of course, there's a workplace impact to all of this, and a couple of things to keep in mind in terms of new laws. Number one, just had a question regarding testing. Should it be a supervisor that drives? Yes, I would recommend that a supervisor or somebody in a management position drives that employee to the testing location. I mean, one of the reasons you want to do that too is you want to make sure that they go directly to the testing location and they don't drive around for 3 hours and then show up at the testing location. So good practice to have a supervisor or a manager. It doesn't have to be their supervisor necessarily, but someone in a management position that drives that employee to the testing location. Okay, so one of the things that California has added now to the harassment training requirement, and this requirement applies to employers with more than 50 employees. If you have more than 50 employees, you have to train your supervisors regarding sexual harassment and abusive conduct in the workplace every 2 years. And California has now put a new module into the training that is required, and that your harassment training must include components on gender identity, gender expression, and sexual orientation. What does that mean? It means you have to talk about employees who are transgender and their rights. You have to talk about employees who may be transsexual and their rights. And you have to talk about employees who are gay or lesbian and their rights to be free from harassment. So that has to be now included in your harassment training. And it's important for the workplace that all the supervisors and managers know how to deal with those particular situations if they come up. Next, you have to maintain policies that prohibit discrimination and harassment based on gender identity and expression. So, in your sexual harassment policy, and everybody should have a sexual harassment policy that is distributed to each and every employee, whether that's in the employee handbook or in a separate policy, you must make sure that that policy says we prohibit discrimination based on gender identity and gender expression. And you should specifically mention transgender or transsexual expression. Those are protected classifications. People are protected from harassment, and you need to make sure that that's set forth in your policy. The other thing I would say is that it's just really important. If you haven't been doing sexual harassment training on time, you need to get it done. Even if you don't have the requirement to provide sexual harassment training because you have less than 50 employees, given today's news media reports on harassment in the workplace, I think it's a good idea to have harassment training. And some clients of mine are even having harassment training, throughout the workplace, not just for the supervisors. It's important to help protect you in case you do have a harassment lawsuit down the road. So we have another question. Does it matter what type of drug test that you have employees take? Well, I think the answer to that question is it depends. It depends on what kind of job it is. If that job is governed under DOT regulations, Department of Transportation regulations, there's specific requirements about what type of test is administered. A lot of employers have gone away from the urine test because of the ability to cheat that test. So you can do urine, you could do breath, you can do blood. It does not really matter. That's usually up to whichever testing location that you use. But in terms of marijuana, I think that would show up on any of those tests. Okay, good question. All right, so that's enough about harassment and discrimination. Let me talk about immigrant protections. This is another new law here in California. California has been at the forefront of trying to protect the rights of immigrants, whether they are documented immigrants or not. And California decided that they wanted to take action to protect people here who may be undocumented from raids by ICE. So what California decided to do is pass a law that prohibits an employer from allowing ICE agents on the premises without judicial warrant. You may have seen on the news that recently ICE conducted some raids at 7-Eleven stores nationwide, including some stores here in California. And in California, at least, if they did not have a judicial warrant for that raid, the employer was supposed to prohibit the ICE agents from coming onto the property, which of course puts employers in a terrible situation. You've got federal law enforcement agents at your door, and you have to tell them, no, you can't come in, you've got to go get a warrant. But that is what California law now requires. Also, if you get a notice from ICE that they want to review your employee records, you must require a warrant or subpoena from ICE before you turn those records over to them. And you have to provide notice to the employees within 72 hours of receipt of a notice of inspection from ICE. And that's probably a little more common than ICE actually showing up at your doorstep. Sometimes they will give a notice that they want to review all the I-9s. And the new law requires you to tell ICE you're not going to turn anything over unless they provide a warrant or a subpoena. Now, hopefully ICE is going to go through the process of getting a warrant and subpoena before they issue a notice of inspection. But ICE isn't required to follow California law. They're a federal agency, so they don't have to do that. And again, it puts the employer in a real tough situation. If there is an inspection of records, you also have to provide notice to the employees of the inspection results. Hey, ICE came in, they looked at all the I-9s, they said everything is hunky-dory, no problem. Or ICE came in and found that there were problems with the I-9s, and we will be going through a process to make sure that our I-9s are correct and everybody is documented. Here's the kicker. This new law provides fines for employers of up to $10,000 if they don't comply and they let ICE come in without a warrant, or they let ICE look at those records without a subpoena or a warrant. Now, there's a question under the law of whether or not this new statute is preempted by federal law, because as you probably all know, federal law governs immigration, and federal law governs immigration enforcement. And there could be an argument that this law interferes with the federal requirements for immigration enforcement. It remains to be seen whether or not this law is going to be upheld, but in the meantime, I think to be safe, if you do have ICE show up, it's probably best to call counsel immediately and make sure that ICE has done whatever they need to do to get the warrant and provide that warrant to you before they come in. Question. Would the notice to employees have to go just to the employees that something was found on their I-9, or would it have to go to all employees? The notice is to all employees. And the notice is not, you're not going to specifically say, hey, just to let you know, Jenna's I-9 was wrong, okay? You would have a general notice that says that there was an inspection, and as part of that inspection, the immigration officers found discrepancies in the I-9s, and there will be further action taken, and we will notify any individual employees that are effective of those individual actions. Somebody else just asked if they just joined in, will the PowerPoint or webinar be able to review? The answer to that is yes. We are taping or recording this, and it will be available for review up on our website, which is www.cwlawyers.com. Oh, CumminsandWhite.com. I always mess that up. And also, if you want a copy of the PowerPoint slides, please send me an email. I will be happy to send them to you, and my email address will be on the last slide. Okay. Let's talk about our next subject, and we are getting towards the end of California. This has to do with minimum wage. I think probably, hopefully, most of you are familiar with the fact that the state minimum wage increased effective January 1st. It is now $11 an hour for employers that have 26 or more employees, and it is still $10.50 for employers that have 25 or less employees. So, state minimum wage has gone up. It will go up again in January of 2019. It will be going up to $12 an hour for employers that are large with more than 26 employees, and it will be going up to $11 an hour for employers with 25 or less. But the important thing here is that we also have local minimum wage ordinances. And this is where it gets a little tricky, because in their infinite wisdom, LA City and County decided, no, we're not going to match the state. We're going to have all these increases go into effect July 1st. So, July 1st, 2018, the LA City and County minimum wage will be going up to $13.25 an hour for large employers. It is currently $12 an hour. And it will be going up to $12 an hour for small employers, employers with 25 or less employees. Now, who does that apply to? It applies to any employers who have employees working within the city limits of Los Angeles for more than 2 hours a week, or within the county of Los Angeles, provided they are in an unincorporated area. So if you're in Los Angeles County, but you have employees working within the city limits of, let's say, Torrance or Downey or another incorporated city within Los Angeles County, that minimum wage does not apply to you. The state minimum wage applies to you, $11 an hour, or $10.50 if you have 25 or less. So you have to look at a map. You literally have to look at a map to figure out, where are my employees working? And this gets very, very difficult for employers that have transitory employees, because even if your home base is in Torrance, if you've got employees that go out every day and work in the city, within the city limits of Los Angeles, you must pay them the LA City minimum wage, even if they work a half day in Los Angeles, for the hours that they work in Los Angeles. Also, LA City has sick leave rules that require a higher rate of accrual than the state law. As you probably know, state law is 24 hours. That's the minimum sick leave accrual. And this is only in LA City, if employees are working in LA City, they accrue at a higher rate, 48 hours per year. So just keep that in mind. Make sure that you're looking at that if you've got employees who are working in the city of LA. There's also other cities that have adopted minimum wage and sick leave ordinances. If you have employees working in these cities, Santa Monica, San Diego, Pasadena, San Francisco, etc., you need to make sure that you're following those ordinances. So just mention that. It's something that has been around for a couple of years, but because it changes mid-year, I just wanted to highlight that. Okay, let's talk about, very briefly, a couple of California court decisions, one of which is kind of interesting. This first one is a case called Nakai versus Friendship House. And the reason why I wanted to highlight it is because it deals with an issue that I run across quite a bit, which is family members in the workplace. This case involved an employee who was fired by his employer after experiencing marital problems. He was having problems in his marriage. Well, how does that have to do with employment? Because he happened to be the son-in-law of the CEO that fired him. In other words, the CEO of the company was the mom of his wife. He was married to the daughter of the CEO, and he and his wife were having problems in their marriage. Mom found out about it, was not too happy, and said, "You're out of here." So the employee sued for marital discrimination, because one of the classifications that's protected under California law is your marital status. And he argued that, hey, my marital status my problems I was having in my marriage played a part in this decision to terminate me, and that was a violation of California law. And the court got a hold of this and said, yeah, no. Marital discrimination is not based on whether you're having problems in your marriage. It's based on membership in a class. So you can't discriminate against people just because they're single. You can't discriminate against people just because they're married. You can't discriminate against people just because they're divorced as a class. But the fact that mom wasn't happy with you because you weren't getting along with her daughter, that's not protected. And so the court dismissed the claim. Yay, a win for the employer. Okay, one other one that happened to be a win for the employer, and this is a case called Mendoza versus Nordstrom, Inc. In this case involved, and this is a Supreme Court case, it involved employees claiming that they were not getting their 1 day of rest for each 7-day work week. Under California law, employers are required to give employees 1 day of rest each 7 days of work. And the employee in Mendoza versus Nordstrom said, hey, they're requiring me to work 7 days in a row, and that violates state law. And the issue was, does the 7-day work week in the statute mean a rolling 7 consecutive days, or does it mean one discrete work week, let's say Monday to Sunday? And the court in Mendoza said, no, it means 1 day of rest in a 7-day work week. It doesn't mean 1 day of rest in any 7 days worked. So Mendoza lost. Employees can be required to work 7 consecutive days if it stretches over 2 work weeks. So for instance, employee works Wednesday, Thursday, Friday, Saturday, Sunday, Monday, Tuesday. But the established work week runs from Monday to Sunday. So that 7 consecutive days was over 2 work weeks, no harm, no foul. Now, does the employer have to absolutely give an employee a day off every work week? No. If the employee voluntarily wants to work 7 days in a row, they are allowed to do that. But you cannot require somebody to work an entire work week 7 days in a row. Okay. Let's talk about some federal developments very quickly. As I said earlier, the good news is that under federal employment law, the rules are being relaxed. And one of the big rules that was announced during the Obama administration was that the Department of Labor said we are going to change the rules regarding eligibility for overtime. In other words, we are going to make it easier for employees to say, I am a non-exempt employee and therefore entitled to overtime. And the way they were going to do that was they were going to raise the minimum salary for exempt status to something exceeding $50,000, which would have made a lot of people now non-exempt employees and eligible for overtime. The good news is that the DOL overtime rules were blocked by a federal court injunction, and it is expected that that's going to go by the wayside. It hasn't been determined yet whether the Trump administration will issue revised rules, but they've withdrawn the rule, and we should be in good shape on that particular issue. Another important issue that's coming up on a federal level, and that is that the Supreme Court has a case that is currently pending. It's been argued. They haven't issued their decision yet on the legality of class action waivers and arbitration agreements. What does that mean? It means that you can have an arbitration agreement that says that the employee waives any right to pursue a class action claim, and class actions in California are proliferating and are very expensive. But you can have an arbitration agreement that says, I, employee, agree I won't sue you in court or in arbitration for a class action. And the Supreme Court is going to be deciding whether that's legal. And the challenge to that is that the argument is that a class action waiver interferes with employees' rights to engage in concerted activity under the National Labor Relations Act. I won't bore you with all the details. It's a very interesting case, but just be on the lookout for that decision. Should be right around March or April, because if the Supreme Court upholds class action waivers and you don't have one in your arbitration agreement, you certainly want to make sure you get that in there, because it's an important way to protect your company from class action liability. One last thing I want to mention very briefly. Just a couple of weeks ago, the NLRB has overturned a couple of important decisions that were made by the Obama administration regarding joint employer status and bargaining units, the scope of bargaining units. Joint employers, the Obama NLRB said that pretty much any employer can be a joint employer with a franchisee, with a temporary staffing agency. They really loosened the standard for what constitutes joint employment, and that decision was just overturned. The Obama NLRB also said that unions could organize bargaining units, organize groups of employees that were very, very tiny. They could carve it out to a shift or a particular job, and the NLRB overturned that as well. And they went back to the traditional standard of community of interest, which means that if a union wants to organize employees, they got to select a much larger group of employees that all have a community of interest. They can't just carve out a small group. So all very good news on that front. What should you expect in 2018? Wow, and I left a typo in there. 2017 should be what to expect in 2018. 2017 is over and done with. Let me tell you, first of all, I just mentioned about class action waivers and arbitration agreements. I think that there's a good possibility in California there's going to be a renewed effort to restrict the use of arbitration agreements in employment. There was a bill introduced in the last legislature. It didn't get to the governor's desk, but I expect, particularly when we have a new governor, that is going to be renewed. So, you know, use your arbitration agreements while you have them, because you may not have them come this time next year. There was also a bill that did make it to the governor's desk that would ban discrimination based on reproductive decisions. That bill was vetoed, but I expect that to come back. There was also a bill that was vetoed that would increase the requirements for employers to collect data on their employee group and turn it over to the state on things like their age and race and national origin and salaries, et cetera, all designed to further this equal pay effort. But that was vetoed. I expect that to come back next year. One of the other things that's popped up in the local ordinance field is restrictions on scheduling and work hours. San Francisco has an ordinance that prohibits certain employers in the retail space from changing people's schedules without prior notice, from scheduling people certain work hours, et cetera, et cetera. I expect that to spread. I don't know if it'll spread statewide, but I could see LA adopting something similar this year. So that's another thing to keep an eye on. And then, of course, the good news, I expect the Trump administration to continue to relax federal employment regulations. It's, you know, one less thing to worry about. I think that's going to be an ongoing theme over the next 3 years. So that's the good news. The bad news is that anytime, as I said at the outset, the federal government goes one way, California's decided they want to go the other way. So we'll probably have, come this time in 2019, a lot more new laws to talk about. Question was, where can we find the information on joint employers? If you Google NLRB joint employer, that decision will pop up, and you can look at that and see what the NLRB said was the standard that should be applied. Basically, they went back to the old standard, which is if an employer has a temporary staffing agency or another employer that is supplying them employees, okay? And that employer exerts significant control over the day-to-day work of those employees, or determines those employees' wages, or determines the policies that will apply to those employees in the workplace, then that employer is going to be a joint employer. The loosened standard would have said, if, for example, you're McDonald's and you have vague rules about what the uniform should look like in the franchisee's McDonald's, even though you have no control over the day-to-day work, you have no control over the wages, you have no control over anything having to do with labor policies, you would still be a joint employer. If you want more information on joint employer status, please give me an email. It's a pretty complicated topic, but I'd be glad to go over that information. So speaking of my email, there is the phone number, my email address, our website, and our employment blog. Again, I want to reiterate, if you have any questions or you want a copy of the slides, please shoot me an email. I'll be glad to send them off to you. And if you have any questions about any of the laws that we covered, feel free to give me a phone call too. I'd be glad to talk to you. Question: regarding parental leave, can an employee request to use accrued vacation or sick pay during the leave? Very good question. Couple things. When it comes to accrued vacation or PTO, an employee can request to use that in order to get paid as part of the leave, or the employer may require that the employee use that as part of the leave. You can have a policy that says, hey, if you're going to take parental leave and you got PTO on the books, you got to use your PTO, okay? And then that employee can take their PTO and then be eligible for paid family leave. Sick pay is a different story. Sick pay is for sickness or to care for a sick family member. The parental leave law is strictly designed to grant leave to care for a newborn, okay? So the employee would only be able to use sick pay if, in conjunction with a request for parental leave, they also submitted documentation to say that the newborn is ill and they're taking sick leave to care for the newborn. But they just can't automatically get sick pay if they decide to stay home with the baby. Hope that answers your question. My advice would be that if you now are governed by this new parental leave requirement, that you amend your handbook or you put out a new handbook that contains a detailed description of parental leave and addresses things like using vacation or PTO or sick leave during parental leave, so that you've got that all set forth in writing for the employees. One of the things I did not mention about parental leave, because almost everybody now uses a service that updates your employment posters, but if you don't, there is a new employment poster on that, so you want to make sure that that's up and available for employees. Other questions? Okay, I want to thank you all for attending today. I want to thank you all for your questions and your participation. We really appreciate it. Again, just to reiterate, if you have any questions, please feel free to send me an email or give me a call. I'll be glad to answer any questions that you have, and we appreciate your attendance today. Thank you very much. Have a great 2018.